Yes.
The old case will 2016, 15. So it may come up for hearing, Lord. RSC.
When?
After viewing, will immediately after view. The information on
In the month of May?
What?
In the month of May?
May.
1st May?
File. First May, second May. First May probably holiday.
1st May is Thursday. 2nd May, Friday. Hearing matter not on Friday.
File.
1st May.
Yes.
Map Lord. My lord, one part hot matter, my lord. It was supposed to be listed on 28th of March, my lord, but unfortunately it has not been listed. So may I pray, my lord, the matter be listed after tomorrow on Friday, my lord.
Partner matter. Friday.
Part hot matter.
4th. Monday, 7th.
7, my lord, because lordship, it was a fix for the consideration of the interim order matter. We'll make an effort, my lord, on
Lordship on 5th, Saturday, it is open.
no, Saturday I'll be out of station.
But Mr. Borboya,
Yes.
you please see the matter. The respondent authorities have passed the order pursuant to direction of this court.
My lord, there was
Single
no
judgment.
specific direction, my lord. That is my case.
Pardon?
There was no specific direction. That
No,
honorable
in their
court said, my lord,
affidavit, they
shall
have,
not be
in
disturbed.
their affidavit, they have categorically mentioned person to, and in the impugn order also, they have mentioned that person to direction
My
of
lord,
this
wrong
court.
interpretation, my lord. That I'll place your lordship.
Huh.
Let it
No,
come on Friday, my lord.
No, see, but whether we can grant any relief
That your
against
lordship,
the order passed by this court.
my lord.
So you see whether is it the proper course, whether review is review can be the appropriate course of action or the appeal.
My lord, I will
You
take
see
it.
the matter.
We'll see. Let it be on Friday, my lord.
Friday, possible.
Monday, Friday, we have so many cases. It will take lots of time.
Monday then.
Monday, 7th.
May I please, Your Lordship? Lordship, the concern of the other side. Counsel for the petitioner, I beg to mention item number 28, Lordship. In fact, in this matter, I am appearing on behalf of respondent number 12 to 16. And I had filed a vokalatam also, but it is not on record. I will verify.
28.
28, Lordship.
Yes, Mr. P.N. Sharma, learned counsel appearing for
Respondent number 12 to 16.
respondent number 12 to 16 with consent from the other side. Price for listing the matter
After 2 weeks, Lordship.
after. Any objection? After 2 weeks.
No.
After view vacation then.
Matter.
After view. There.
May I please the lordship, my lord, I pray for listing of a motion matter, my lord, new civil revision petition on Friday, my lord. The civil revision petition in respect of the interim order, my lord. On Friday, new motion matter, my lord.
So on 5th, Saturday,
5th, my senior will not be there, my lord.
so many cases already.
Friday, a lot of cases.
New cases, my lord, motion matter.
No, that's all right. A new case, we have to pass the order.
Yes, my lord.
7th, Monday.
Yes, my lord. Correct. Oblige, my lord.
This matter straight to release of the amount deposited by the insurance company. It will be released
When?
on Friday. Fourth,
After Bihu,
or dollars.
on
So,
10th.
then on Monday.
Monday.
Monday. Yes.
Wait, please, Your Lordship, I beg to mention an item for listing, Lordship, and RSA
When?
for orders, Lordship.
When do you want?
Next week, Lordship.
On
Next week.
10th. 10th.
10th.
May I
Thursday.
petition?
10th. Thursday.
Yes.
May I petition, Lordship? I beg to mention item number 14 for adjournment, Lordship. My senior counsel is got accident, Lordship. Car accident.
Mr. Your good name?
Espego.
S.
Espego.
S. Pego, learned counsel appearing on behalf of
Yes, sir.
learned counsel for the appellant with consent from the other side. You inform the other side?
Yes, Lordship.
Press for listing the matter after
7/5/25, Lordship.
7.
7/5/25. 7 May,
May.
Lordship.
Okay.
My lord, motion item number 2, my lord. The copy number 3 has expired, so I need some time for filing subsequent petition, my lord.
Item number 2.
Item number, motion item 2. Reference number 3 has expired.
Mr. Murzo, learned counsel for the petitioner submits that respondent number 2
Three.
of this petition suffered demise. And there is a requirement for implement of legal heirs
Yes, my lord.
of the respondent number 2, and therefore praise for listening the matter. When?
After review, my lord.
After review. Review. Yes.
May it please your lordship, I beg to mention item number 32 and 33 with the consent of the appellants. Lordship may kindly be pleased to adjourn the matter for the day.
Mr.
D. Rathi.
The learned counsel for the respondent with consent from the other side. Praise for listening the matter. After?
Lordship, in the 4th week of April, any date may be fixed in the 4th week of April.
4th week of April, 30th April, please.
Deeply obliged, my lord.
May I please, your lordship? Lordship, I beg to mention for listing of a unlisted matter today, lordship. What happened in this case, lordship, that a RSA was dismissed for non-prosecution, lordship. In this RSA, what happened, lordship, newly engaged counsel name was not appeared on that particular cause list, lordship. Therefore, they missed the case, lordship. And there is an interim order, lordship, for stay of execution proceeding, lordship. The interim order is also vacant. in
When
this
do you
case.
want?
Lordship.
Today?
Yes, lordship.
Today not
Maybe the last
possible,
item,
madam.
lordship.
43 matter,
You see the cause list?
admission board. Last,
Day after tomorrow. Tomorrow is a hearing day. On Friday we will try. Or Saturday.
Lordship, kindly on Friday, lordship.
Friday?
Yes, lordship.
Yes.
I am grateful, lordship.
From the other side, I beg to mention item number 1. Matter may be come up after review, your lordship.
Miss, your good name?
P. Day,
P. Day, learned counsel appearing on behalf of
on behalf of SP Roy, your lordship.
Mr.
Mr.
SP Roy,
For respondent
learned
number
counsel for the respondent number 1, 2, 3. You inform the other side. With consent from the other side, first for listening the matter after vacation. Clear.
obliged, your lordship.
May I please, your lordship? Your lordship, I beg to mention one IA for listing, lordship. Kindly
When?
the matter may be listed on Friday, lordship.
Saturday.
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 5th.
Bless.
May it please your lordships. Lordships, an adjournment request was circulated with regards to item number 16, your lordships. Consent of the other side was taken, your lordship. May the matter be fixed. In the month.
Mr. Your good name?
T. Kashyap, your lordship.
T. Kashyap, learned counsel for the
Appellants, your lordship.
appellant. You inform the other side?
Indeed, lordship.
Okay. With consent from the other side, press for listening the matter.
On the 23rd of April, your lordship. After review.
23rd of April. Yes, fair.
Much obliged.
May I pray for listing of an matter on Monday, my lord.
When?
Monday, my lord. Monday.
Oh,
Monday,
hearing.
that for orders only. Obliged.
May I please, lordship? Lordship, I beg to mention for listing, lordship. The matter, lordship, RSA filing number 3442.
When?
Lordship, if possible, on Friday.
5th,
Saturday.
Saturday, 5th.
Obliged.
May I please, your lordship? I beg to mention item number 41, my lord.
Property?
41 on the daily list. In this, my lord, Mr. G. Suma has appeared, madam. Lordship may not like to take up this matter, lordship. 41, lordship.
List the matter before any other bench would help me.
Motion item number 3.
Wait, please, your lordship. Lordship, this is for motion, lordship. I'm challenging the order whereby I am a stranger in a decree, lordship, in a execution case, lordship. What has happened? A decree was passed way back in the year 1999. The decree holder has filed an execution case in the year 2005. It continued and it was dismissed for default in the year 2012. After that, lordship, the decree holder has executed agreement for sale in my favor, lordship. And I was put to possession. And lordship, after that, lordship, in the year 2018, the decree holder fraudulently again revived the execution case. The execution case continued, lordship, and we had no idea about it. Only in the month of February 2025, lordship, the police came to evict us, Lordship. Then we came to know that the execution case has been is pending in the plot of land where I am in possession. Accordingly, Lordship, I have filed an application under Order 21, Rule 97, Lordship. And in that Lordship, we have prayed for an interim prayer, Lordship.
No, is there any reference to your application in the impugn order dated 5/2/2025?
Yes, Lordship.
Where?
First, Lordship, that first one, Lordship.
Impugn order is 5/2/2025.
5/2/2025.
Yes. Where is the reference of your petition?
Lordship, I'm coming to it, Lordship. Lordship, may kindly see page number 122. Page number 122, Lordship. Ms. J case arises out of an application dated 2/4/4 of 2025 filed by the petitioner under Order 21, Rule 97 to pass an order declaring that the petitioners are not bound by the ex parte decree dated 7/9/1999, passed in title suit number 13 of 1995, and they are not evictable at the instance of the decree mentioned in the Schedule B. The permanent injunction and an interim
No,
order to
whether the learned executing court had passed two order on the same day?
Yes, Lordship. This is with respect to my petition. And Lordship would find that Lordship the executing court has already issued the writ, and as on date the payment for police force has also been given. Now, Lordship, this is the same case where this honorable court has already interfered, Lordship, with regard to other third parties, Lordship. Lordship would find it page number 124. Lordship, this CRP 57 of 2021. They came to know about this case before us, and they had approached this honorable court in the year 2021. And Lordship, this invite order dated 5/6/2021, this honorable court has stayed the execution proceeding with respect to these petitioners. And Lordship, this is also referred in the writ issued. Lordship, may kindly see the writ which has been issued, which I have annexed, Lordship, in page number 65. The operative portion of the writ, Lordship, is at page number 66. You are hereby directed that the plaintiff in possession of the same, and you are hereby authorized to remove the defendant, judgment debtors, and other persons bound by the decree who may refuse to vacate the same by demolishing and removing all the permanent and semi-permanent constructions, and put plaintiff decree holder in possession over a specifically mentioned land in Schedule A, herein below, excluding the land mentioned in Schedule 2 as per High Court order dated 25/11/2022 in CRP number 57 of 2021. So, Lordship, in the same case, Lordship, this honorable court has given an interim order with respect to one set of petitioners, and we are the other set of petitioners, Lordship. And Lordship, this is Lordship, the law in this regard is quite clear, Lordship. Lordship, when a third party who is in possession of a land which is to be executed, then the law has been settled by Honorable Supreme Court, Lordship.
Yes, you produce the decision.
And Lordship, this decision has also been considered in the order passed by this Honorable Court, Lordship, in page number 124. Lordship, the operative portion of this judgment of the Supreme Court is in para number 5, 6, 8, and 9. May I just read the relevant portion, Lordship? Lordship, it's the same case, Lordship. The petitioners are different, but the case is the same, which I have annexed in page number 124.
Okay, we'll see. But I was under the impression that this order dated 5/2/2025 in the title execution case number 6 of 2005 is the impugn order.
Oh, no, Lordship. That is the impugn order, but in page number 122. Lordship probably has read it in page number 99. That is in respect of the main execution case which is pending. On the execution case on 5/2/2025, I have filed an application along with other 9 petitioners, application saying that I am in possession of the land. I was not aware of the decree, and the land which has been transferred is prior to the decree. No, after the decree was passed. Lordship may kindly see all these affidavits, all these agreements from Annexure 1 till Annexure 9. All these are the agreements. Lordship may kindly see the date. Date is very relevant. Lordship may kindly see the date.
Okay, Mr. Deka, we'll see and we'll pass the order. It will take time to go through the order of this coordinate bench of this court and also the decision referred by you. So we'll go through it and pass the order.
Lordship, if I may just read the because this is absolutely similar. All the
Okay.
facts is the
Okay,
similar.
we'll examine the same and we'll pass the order.
Number 4.
Hello.
The similar matter has already been dealt with by this honorable court. Lordship, page 56, my lord. Page 56, my there are 2 defendants. One is Abdul Qasim and one is Subur Ali.
This is a civil revision petition.
Yes, madam.
So this revision petition is prepared against the judgment and decree.
Madam. Madam. There is a
Is it
similar order,
maintained?
Lordship passed, my lord.
Is it maintainable?
Yes, madam, because section 6 demands that the appeal is not maintained. That's why Lordship has made observation.
Section?
Section 6 of the Specific Relief Act, my lord. There is no any provision for appeal. That's why, my lord, revision petition. Lordship has already made it observation, my lord. One defendant already approached for this honorable court and Lordship dealt with the matter. This may be taken together, my lord. I'm defendant number 3 and this is Abdul Qasim, defendant number 2. Section 6, subsection 3, my lord. This may take together, my lord, because the Lordship already passed the similar order. I'm Subur Ali, defendant number 3.
So against the same judgment.
My lord, same, my lord. Common judgment, there are two defendants. They both parties the said by virtue of said it. One already prefer revision petition earlier, lordship has dealt with the matter, and this is similar. Lordship otherwise pass the same order here, my lord.
Heard Mr. Somalia, learned counsel for the petitioner. This revision petition under section 115 of the Code of Civil Procedure is directed against the judgment that dictated 21/12/2024, passed by the learned civil judge junior division number 3 Nagaon, entitled sub number 93 of 2011. It is to be noted here that by the judgment and decree dated 21/12/2024, the learned civil judge junior division number 2 Nagaon had dictated the suit for eviction of the defendant by demolishing and removing belongings and land from the scheduled premises along with cost of the suit. That notice be issued to the respondents returnable in 4 weeks, step be taken by registered post with AD and also by usual process within a week from today. This will also call for the record from the learned trial court. Is there any interim pair here,
My lord, yes, my lord. Stay, my lord, because similar order already passed, lordship. This may also be passed.
Mr. Somalia further submits that another who is that person?
My lord, another person name is my lord Kasim. My lord Abdul Kasim.
Abdul Qasim. Who was he in the title suit?
Same, my lord. Title suit. The different number he was.
That another petitioner who was the defendant number 2 in the title suit number 93 of 2011 had already referred one revision petition before this court, being the revision petition number
40 of 2020.
40 of 2025. And in the said revision petition, this court was placed to grant stay of the interim judgment and decree dated 21/12/2024 till returnable date. And as such, similar relief may be granted to the present petitioner also. Taking note of the submission of Mr. Somalia, learned counsel for the petitioner. The interim judgment and decree passed by the learned dated 21/12/2024, passed by the learned counsel. No, learned civil judge, junior division number 2, Nagaon, stands state till returnable date. Till returnable date. This civil revision petition number 30 of 2025 shall be taken with the civil revision petition number 40 of 2025.
May I pray, my lord, this may be take together, my lord. Observation may be take together, my lord, with 40, my lord. This matter may also be take together.
Already ordered.
Item number 5.
Keep look.
May I please? Also, by way of this revision petition, petitioner challenged the order dated 30/11/2024, whereby the execution application filed by the petitioner for execution of a decree passed by the Dubai Court of First Instance has been dismissed, holding that that is decree is not executable in view of section 13D of the CP. So at this stage, notice will go also. Annexure 8 lots. Page 67.
Page 60.
7. Impugn order. Operative part at lordship, page 92. Lordship got it. Page 92.
Third, Mr. S. Dekal, Learned Counsel for the this petition under section 227 of the Constitution of India is referred by the petitioner challenging the correctness or otherwise of the order dated 30/11/2024 passed by the learned civil the senior division Gulagat in money petition case number 3 of 2023. Is to be noted here that by impugned judgment in June 30/11/2024, the learned civil judge senior division Gulagat has held that the decree which is sought to be executed in Gulagat is not executable by that court. By that court. Decree passed by a court of UAE, Department of Legal, UAE in case number 445 of 23, commercial, is not executable by that court. Whereas the petition and the documents enclosed with and also whereas the impugned order dated 30/11/2024. Let notice be issued to the respondent returning for which that be taken by the secretary in the legal process within a week from today. Please the matter of that for which
Obliged.
Item number 6.
May I please, if you want. My son died in a road accident that is on 12/4/2022, Lordship.
no,
According-
Mr. Soikia,
Yeah, your Lordship.
so this accident took place prior to the Amendment Act or after the amendment?
Your Lordship, after the amendment act, Lordship, only 4 days. After the amendment act, so my case is not.
So is there any provision there?
Lordship, there is no
Oh,
provision.
condemnation of delay.
Lordship, there is a Honorable Supreme Court, even the Allahabad High Court is there, Lordship. If any claim petition has been filed within a period of 1 years, Lordship, so should be considered. Actually, in this case, Lordship, I have explained that due to delay, Lordship. Yes, because I am the.
You
mother
have
of the
explained,
victim.
no, Mr. Soikia, you have explained it, that's all right.
Yes,
But in absence of any statutory provision, can the court condemn the same?
yes, therefore, Lordship, limitation act, I have filed condemnation petition as per the provision of limitation of under section
Whether limitation
5
act
of
is
the limitation
applicable,
act. There is a,
whether limitation act is applicable there.
yes, this is also applicable. My condemnation petition I have filed, your Lordship, same has been annexer B, page number 16, Lord.
Then where is the judgment of Supreme Court?
Yes, my Lordship. Analal versus DP Vijay Bhargia and other Supreme Court of India judgment.
So it
Herein, Lordship, the condemnation petition, the claim petition has been filed after the statutory provision for 4 days, Lordship. Therefore, the learned tribunal has initially rejected the claim petition, Lordship, and subsequently same has been filed before the High Court, Lordship, and High Court has rejected. Therefore, the Honorable Supreme Court has set aside and quashed this order and remand back this matter.
It is a death case or injury case?
Lordship, this one is a.
No, no, this one,
My
your,
case is
your
the death case.
death case.
So I am the mother of the victim, Lordship, so could not file this present claim petition within stipulated period, Lordship. There is a possibility, Lordship.
Whether
being
you
a
have
mother
filed
of the
any
victim, Lordship.
FIR before the police station?
Lordship, FIR immediately filed as because there are the two number of victim is there, Lordship. The FIR has been filed another one, Lordship, and other person has do needful, Lordship, regarding Form 54 and certain reason, Lordship. But Lordship, when I came to know that there is a provision that claim petition should be filed after expiry of the said statutory provision, Lordship, it
No,
has
no,
came to my
no.
knowledge and I
In
have filed.
connection with that accident, one FIR was registered.
Yes,
Registered
FIR was raised.
immediately after the accident.
Accident, as because there are the
Okay,
two number of
you-
victim is
Mr.
there, another party
Mr.
has no
Soikia.
needful, Lordship. Yes, Lord.
That's all right. You produced that copy of FIR before this court on next day.
Yes, your Lordship.
Heard Mr. N. Soikia, learned counsel for the petitioner. List the matter after or before view vacation.
Lordship, after vacation, Lordship.
List the matter after view vacation so as to enable Mr. Soikia to produce the copy of FIR which was lost with the which police station?
Lordship, Satgaon Police Station.
Satgaon police station. Immediately after the occurrence. By who lost the same?
Lordship, another one, Lordship, there are the two number of victim, Lordship.
By another victim of the case. Another victim of the accident. So do we fix it at?
As your Lordship convenience.
On 25th April.
May submit same document by filing additional affidavit.
Yes, by filing an additional.
Item
Keep your-
43.
My lord, in this case, basically issue is very small, my lord. My lord, we were given the opportunity to cross-examine the witnesses of the my lord, plaintiff. But my lord, because of the illness of the my lord counsel, they could not, my lord. And my lord, ultimately, the honorable court, my lord, says that they are debarred from cross-examination, and the cross-examination, evidence of PWs are, my lord, expunged. Basically, my lord, may I just raise certain facts before my lord lordship goes into. My lord, this suit was filed in 2010. Basically for a lease of a property of cinema hall in North Lakhimpur, my lord. We are the leaser, my lord, lessee. Now, my lord, that lease was of 74. Thereafter, my lord, they say that there was no lease deed or other things were there. For 20 years, lease deed was there. Thereafter, my lord, in 2007, lease deed was there. That was extended for 35 years at the rent of 5,500. Now, my lord, they say that that has been done by the earlier secretary. He, my lord, committed fraud and all that, and he signed the, my lord, document in favor of us. And they filed the suit for, my lord, declaration and other things. Suit was filed in 2010. This case was, you know, 2 times they have made an amendment. The amendments were rejected. They came to the High Court. Honorable High Court directed that amendment may be allowed. That was allowed. Thereafter, in 2014, we came, my lord, for certain orders, my lord. Ultimately, it was pending here. In 2021, it was disposed of. In 2024, my lord, again amendment has been made, making, my lord, the district registrars and other, my lord, sub-registrars and all party without TS. Ultimately, if your lordship kindly directly come to page 56, my lord. I'll come to the impugned order, my lord, before your lordship will kindly see.
So you tell me for how many dates the case was listed for the evidence of the plaintiff?
Well, 2 times it was fixed. Your lordship will kindly come to then directly 18.2, my lord, page 58. This is the first order, my lord. After the, my lord, they took, my lord, 3 dates
to file the, my lord, affidavit, evidence on affidavit of the plaintiffs, my lord. They filed on 30th, then second, they again filed on, my lord, 6/2, and ultimately they completed it on 18/2. 18/2, my lord, for first time. Your lordship, I'm not going in the detail, my lord. Both the sides are, last para, both the sides are directed to appear before the Advocate Commissioner on 25 and 27 for cross-examination of PW without fail. Fix itna for report of Advocate Commissioner. Now, my lord, we could not cross-examine because of the illness, then we filed an application. Your lordship, next page 59. Page 59.
No, here impugn order is dated 17/3/25.
The last impugn order is 27. 17/3.
Other orders are not challenged in this petition.
No, not required, my lord. Your lordship will kindly see because my petition was.
Okay, all right.
Earlier orders are not.
So, legally, you are entitled to 3 adjournment.
Well, minimum 3, my lord. I'm not going to that also, my lord. My lord
You
will
have
kindly see.
availed only 2.
2, my lord. My only submission, my lord, let the matter go back. We may be given the opportunity. Fixing
But where is the medical document of the
medical
advocate
document, my
doctor?
lord, I have enclosed here, my lord, all the documents. Because he
Page
came.
number?
66 onwards, my lord. Then 68. Type করে দিব না লাগে নাকি এখানে?
Okay. Okay. Heard Mr. K. Agarwala, learned senior counsel assisted by Mr. A. Das, learned counsel for the petition. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the correctness or otherwise. Read with section 151 of the Code of Civil Procedure. Challenge the order dated 17/3/2025.
And my lord, 21.
And
page
21/3/2025,
Yes,
filed by the learned Civil Judge Junior Division number 1, North Lochinpur. In title suit number 26 of 2010. It is to be noted here that by the impugn order dated 17/3/2025, the learned civil judge Junior Division North Lochinpur has rejected the petition filed by the defendant for adjournment and debarred the defendants from cross-examination of the PWs and thereafter expunge the evidence of PWs.
There cannot be any expand. Evidence can't be expanded, my lord. Otherwise, everything will go away, my lord, from the record.
And by the impugn order dated 21/3/2025, the learned civil judge Junior Division number 1, North Lochinpur has fixed the case for evidence in affidavit of DWs and rejected the petition filed by the petitioner. So, this petition number 486 of 2025 was filed for recalling the order dated 17/3/2025. Is it?
My lord, 17C, it was rejected, and on that day also, my lord, direction was given to my lord, file DWs, my lord. Now, my lord, on next day, we moved on another application. Page 62, your lordship will find first.
For recalling the earlier order.
Yes, my lord.
Where is the petition?
63, my lord. Page 63, my lord. Page 63, 64, my lord.
For allowing the petitioner to cross-examine the witnesses. Mr. Agoral, learned counsel for the petitioner, submits that on 17/3/2025, the witnesses of the plaintiff could not be cross-examined by the petitioner as his engaged counsel was absent on that day on account of his ill health. But the learned trial court has dismissed the petition and expunged the evidence of the PWs. And thereafter, on 21/3/2025, another petition being petition number 468 of 2025 was filed under section 151 of the CPC for allowing the petitioner to cross-examine the PWs on the ground that the engaged counsel, namely Biman Bora, was in Guwahati for his medical treatment. Enclosing some medical documents in support of the said claim also, but the learned trial court has dismissed the aforesaid petition and thereafter placed the matter on 4/4/2025 for evidence on affidavit of the PWs. Mr. Agoral further submits that though the case was instituted in the year 2010, yet on various occasions, the case was stayed by this court.
No, it was not under stay for 7 years, my lord, here.
It was
In
stayed by this
2014, I
court
have given the numbers and
for
all that.
almost 7 years,
And
and
it was disposed of in 2021. I have given the,
thereafter the petitioner herein availed only 2 occasions, though as per law he is entitled to 3 adjournments. 3 adjournments. And that unless the impugned orders dated 17/3/2025 and 21/3/2025 are set aside in clause, then the petitioner is allowed to cross-examine the witnesses and serious prejudice will be caused to the petitioner. And therefore, Mr. Agoral has contended to allow this petition. Having heard the submission of Mr. Agoral, learned counsel for the petitioner, I have carefully gone to the petition, the documents as on record, and also peruse the impugned orders dated 17/3/2025 and also the order dated 21/3/2025. It appears that by the impugned order dated 17/3/2025, while rejecting the petition for adjournment filed by the petitioner, he was debarred from cross-examining the PWs and expunged the cross-examination of PWs. No, whether you have cross-examined them.
no, not cross-examine. That's what I'm saying, that it can't be any expansion because, even if I cross-examine, that can't be expunged. Or maybe some mistake may have committed. or I'm not-
By the impugned order dated 21/3/2025, the learned trial court also dismissed the petition filed by the petitioner for allowing to cross-examine the witnesses on the grounds that the case is pending since the year 2010.
They themselves filed the lord in January 2025 and February 2025, the evidence on affidavit. That orders are already here.
It also appears from the record that the petitioner has availed only 2 adjournment, although
Three adjournments.
3 adjournment.
Yes, madam.
3 adjournment. Also 3 adjournments.
Page 55. Page 55 and 56, my lord, these are there. And page 57. Two adjournment, na? Two adjournment. Two adjournment.
First one on 28/1/25.
That on that day, first time for filing affidavit.
On 21/1/2025 and on next date, 30th/1.
31, 31. And then ultimately 6/2 again. 6/2, page 57. They completed the filing on 18/2, my lord.
It is to be noted here that right to fair trial is a fundamental right. And in a fair trial, fair opportunity has to be given to the parties to defend their cases. And denial of fair opportunity also amounts to denial of fair trial. And further, it is well settled that a right to cross-examination, right to cross-examine a witness, apart from being a natural right, is a statutory right. Section 137 of the Evidence Act provides for examination in chief, cross-examination, and re-examination. And Section 138 of the Evidence Act confers a right on the adverse party to cross-examine who has been examined in chief, subject of course to expression of his desire to the said effect. But indisputable such an opportunity has to be granted. Which in bracket C. Zoendo Vistu Thakur versus State of Maharashtra reported in 2009 7 SCC 104. In the case in hand, the witnesses of the respondent herein have filed their affidavit in opposition, but after granting two adjournments, the learned trial court has refused to grant further adjournment and thereafter debarred the petitioner from cross-examination of the witnesses. And as such, the right of the petitioner to cross-examine the witnesses are violated here in this case. And as such, the impugned order dated 17/3/2025 and 21/3/2025 fails to withstand the legal scrutiny, and therefore both the orders stand set aside in trust. The learned trial court is directed to afford one opportunity.
At least two, my lord, your lordship.
No, no.
Because, my lord, my counsel is very old, my lord, and my lord. 4 witnesses are there, my lord. It can't be finished.
How many witnesses are?
Four public petty witnesses are there. Let it be two, my lord. Will my lord?
Two opportunity to cross-examine the witnesses, who is of course subject to payment of cost of rupees.
5,000 will.
No, 10,000. In terms of this CRP.
Lord, the party will appear on 4th, my lord, and the trial court will pass the 4th is fixed, my lord, already.
Next step.
Next date is 4th of Day after tomorrow, my lord. Today is second, my lord.
Appear on that day. The petitioner shall appear before the allotted trial court on the date fixed, that is fourth of
4th of April.
April.
My lord, only one request to my lord, my lord. My lord, the order has to be, my lord, to go. Otherwise, either whether the registry may be directed to, my lord, transmit the order.
So you obtain certified copy.
No, no, we'll obtain, my lord. Only thing your lordship will kindly say that. He has to take it and go to, my lord, yeah.
Publish it before the court on next day.
My lord?
You obtain the certified copy.
No, no,
and
we'll
publish
obtain the certified
before
copy.
the-
Attends for admission.
Much
Item 7.
Your Lordship, before submission, I have a prayer, my lord.
Pardon?
I have a prayer, my lord, before submission. Honorable Court had directed to take instruction about the departmental proceeding in this matter, my lord. So I have not received any instruction, so kindly sometime may be allowed, my lord.
Otherwise, my lord, no departmental proceeding was initiated, my lord. Your lordship will find in the order itself, my lord. Departmental proceeding which was initiated was closed, my lord, without passing any adverse order, my lord. It is already reflected in the order which I have annexed, my lord. Anyway, my lord, since they are praying for, and my lord, matter will be fixed in the next week, my lord. It is 2021 matter, and already there is order of this honorable court, my lord. And
Third, Mr.
AHMR to
A.H.M.R. Sodori, learned Muslim Court of Petitioner and Madam Open for Respondent.
Yes, my lord, elementary department.
Open submits that she have not received the instruction till date. So whether there was any direction for obtaining instruction?
there was no
Yes,
written
my
direction,
lord.
but she was asked
Yes, my
to
lord, honorable
take
Court had
instruction.
directed to take instruction about the departmental proceeding, my lord.
During the hearing, my lord, he was asked to produce, my lord. There is no reflection in the order, my lord.
Okay, pair is accordingly allowed, receipt shall list the matter on. Prior.
My lord, matter may remain
Okay,
part.
receipt shall list the matter as part.
Obliged.
Of March may kindly be paid special.
Yes, Mr. Soliha, have you received any instruction?
Here, I was talking to the officer, Lordship, they have said they have re-endorsed the file back because they were the matter relating to the salary, Lordship. The proposal, the file which they had received was not in the proper format. So they have re-endorsed the file to the Lordship may have it at two, Lordship, I'll be able to give the proper instruction as to why we have returned.
Item 9. Order matter.
In this matter, now court has directed to up-to-date instruction. My lord, here we have not received any instruction from the elementary education. So right now I have no instruction, my lord. So kindly on next week, my lord. Already secondary education department has written to the elementary department regarding the financial queries, whether the past service is countable for the pensionary benefits. This is my instruction.
No, you were not the standing counsel for the secondary education department.
Yes, I am secondary.
You were secondary.
Yes.
Then,
Earlier, he was appointed in elementary department. Section, right?
what Mr.
I alum, my lord.
I alum learned counsel for the petitioner and Mr. P. N. Sharma learned standing counsel for the secondary education.
Secondary education department. You, Sharma?
U. Sharma and Mr. B. Sharma for AG. Respondent number? Three. Respondent number 3. Mr. Sharma submits that though he has received instruction from the secondary education department, yet no instruction has been received from the elementary education department. And as such, Mr. Sharma
Hello.
is for listing the matter.
Since the elementary is party, respondent number 5, so he can directly submit, my lord.
Who is for elementary education department?
My lord, in fact, his entitlement for pension is already decided by this honorable court, my lord. And on last occasion, your lordship also heard this matter, my lord. It may be taken up for after Bihu, my lord, for final disposal, my lord. Issue already decided by this. Well, I have not received the pensionary benefits after retirement. That's why I am appealing for your lordship, my lord.
SSL is the matter after BU vacation. In the meantime, the standing council for the elementary education department shall obtain necessary instruction and place the same before the school on date fixed. Next day, on which an endeavor will be made to finally hear and dispose of this case.
His name may be shown, my lord. Otherwise, they will change, my lord, on every date, my lord.
But no one appears.
My lord. My lord, date may be kindly be fixed, my lord. Since he is already retired, my lord. 29/4. My lord, published it.
Item 10, order matter.
May I please, Your Lordship?
Yes.
Lordship, last occasion, the department has insisted for the representation whether the petitioner has filed or not. That I informed but not received. Lordship, kindly peruse the order dated 20th January 2025. Option আনিব দিছিলে ন তাৰপিছত তেওঁলোকে ৰিপ্ৰেজেণ্টেশ্যনৰ কথা ক'লে মানে Gautik. And Lordship,
Mr. Sharma, you are appearing here?
Yes, my lord.
in
My lord,
18th
your department has wrote a letter to the inspector of school regarding some queries. Number 1, regularization order and subsequent order, if any, passed by the competent authority in support of area claim of the petitioner. And number 2, specific reason for which the petitioner did not receive the incremental benefits.
Lordship, area the petitioner got the area salary, Lordship. Only the incremental benefit is pending, Lordship. And similarly situated person has already got the incremental benefit. Whether they are similar or not, they have.
This is written to the inspector of school from the director.
So this is a letter written to the inspector of school, Nagaon.
Yes.
So whether you have received any reply or not?
No, madam. Not yet, madam. So, madam, sometime may be granted. So that I can get the instruction.
Already last chance has been granted, no? On 20th January and 18th of February.
Heard Ms. M. Sharma,
I'm sorry.
learned counsel for the petitioner, and also heard Mr. Q. Sharma, learned standing counsel for the secondary education department. Mr. Sharma has produced one letter of the Deputy Director of Secondary Education Assam, written to the inspector of school, NDC Nagaon, putting some queries in respect of a regularization order and subsequent order. In respect of, no, in support of the area claim of the petitioner and also specific reason for non-receipt of the incremental benefit by the petitioner. And the report upon the said queries are being awaited and principal listing the matter after vacation. There is allowed recessal list the matter on
28 April.
as part 30.
Highly
The
obliged.
communication produced before the court today shall be part of the report.
Highly obliged.
Item 11.
Wait, please, your lordship. Lordship, my senior conducting counsel is out of station due to his medical treatment, lordship, and leave of absence has been submitted, your lordship. Matter may be adjourned for their lordship.
Monday,
I will reach report.
next week, my lord, it may be.
Next week.
11.
After view, lordship, and please.
After.
Any date, lordship, where for lordship. After view.
Okay.
It-
Or
after view, my lord, it is-
Polita, learned senior counsel assisted by Mr. Learned counsel for the petitioner and Mr.
Take Kanu.
A.K.
Kanu.
Learned counsel appearing on behalf of Mr.
M. Ahmed.
A. Mohammed, learned counsel for the respondent. The learned counsel for the respondent submits that the conducting counsel, Mr. A. Mohammed, is out of station
For his medical treatment.
on medical ground and principal listing the matter after vacation. There is allowed recessal list the matter on
23rd April.
23rd April.
Not my lord, 23rd, my lord, it may be placed on 29th of April, my lord.
29th.
20. Record has come, my lord.
Okay.
29th.
12.
22 Monday হবে না? 29 হলে ভালো হবে।
May it please your lordship, my lord. My lord, here, my lord, I could not submit my WS in time, my lord. So my explanation was there before the honorable court. However, my lord, the honorable court rejected the prayer and refused to accept the WS, my lord. My lord, in my humble submission, my lord,
After how many days you have filed your WS?
some delay is there, my lord. Order is at pace 358 days. My lord, in the petition, he stated he was suffering from certain ailment. My lord, page 28 is the order. Now, my lord, WS, kindly see our WS we filed. It is not that we took time for WS. Page 22 is the WS. But that WS, although it is on record, that has not been on the ground of delay, my lord. My lord, in my humble submission, the order appear, my lord, the word appearing in order 8 rule 1 shall file within 30 days. My lord, that requires no monastic interpretation because that has been decided in the by the Honorable Supreme Court in the Salemba case association case, my lord. That only one judgment, my lord. Kindly to all of you. My lord,
Oh,
that is 58 days, my lord. But just kindly see here, my lord, the stage of the suit also. Suit is at the stage of SR and WS, my lord, in respect of other witness. My lord, here
2008-11 SCC, only paragraph 13, 14 and 15, my lord. And in another case, 2006, only para 7. Jolba, that 2008-11 SCC, my lord, para 13, considering the facts and circumstances of the present case and the statements made.
No, maybe some relaxation can be given.
Yes, my lord.
But not for indefinite period.
My lord, I don't mind, my lord.
In your case, it is 365 days, almost a year.
That's correct, my lord.
Then what is the explanation?
Explanation, my lord, here in the petition itself, although at this stage I have not given the medical certificate, but the medical illness was mentioned in the petition, my lord. And however, we have before this honorable court for the satisfaction that for longer period he was suffering, the documents we have given doctor certificate. However, in the court, trial court, my lord, we mentioned that he was suffering from ailment. On that ground, my lord, kindly, my lord, some consideration.
Had it been supported by the medical document, then trial court definitely would have considered
Yes,
it.
but my lord, trial court could not have, because 90 days for the trial court, my lord, outer limit. And in such cases, my lord, as decided by this honorable court, my lord, that relaxation could be granted by the honorable high court only, my lord, or the honorable Supreme Court after rejection. So, my lord, may I pray like this way, my lord, since delay is a matter, is disturbing your lordship also, by imposing minor cost, my lord, that may be accepted, because we are already filed, that has not been accepted. Because he will also not get the current actual fact in the suit if I don't file the WS, my lord. And kindly see the stage of the suit, SR for defendant number 9, still not service is complete. So those factors may be considered, my lord.
Yet that plea was also taken by my learned friend before the trial court. But the trial court did not get any sufficient ground to substantiate the petition filed by the petitioner. That is why the petition filed by the present petitioner was rejected at that stage. Because sufficient cause must be substantiated by the petitioner. But the petitioner failed, petitioner defendant failed. That is why their petition was not
Now he has produced some medical document.
Yes, subsequently procured, but that document was not before the learned trial court below. So on the basis of that subsequently they have filed a medical document. On that basis, the order passed by the learned trial court cannot be considered by your lordship as illegal. Because that was not given to the learned trial court below. So finding no alternative, the impugned order was passed, rejecting the petition. That is the.
Age is also his 67 years, my lord. And age, keeping in view of the age of the, my lord, applicant also, petitioner also.
Yes.
My lord, he says he cannot say, my lord, in our favor, but my lord, it's up to lordship, my lord. You cannot say, no.
But that's all right. But the delay is inordinate, no? 356 days.
My lord, therefore, my lord, I may not submit, but my lord, lordship for substantial cause of justice, lordship has to see. CPC procedure, for the procedure, my lord, the litigant case should not suffer. Moreover, my lord.
Had it been a 1 month or 2 months, then the matter would have been different.
My lord, then.
Almost a year.
My lord, just, my lord, page 2773 of the judgment, my lord, 2011 SEC, 773, para 14, my lord, middle para 20. There, my lord, it is said, my lord, what is the difficulty of the honorable court that has been dealt with by the honorable Supreme Court, my lord.
In which paragraph?
Para 14. 2008 judgment, my lord. Subpara 20, it is quoted from the judgment of the Salemba Advocate Association. Para 20, the use of was sale order 8 rule 1 by itself is not conclusive to determine whether the provision is mandatory or directory. We have to ascertain the object required. My lord.
What extent this description can be applied?
My lord, here, my lord, that has been said, my lord, the rule of procedure are made to advance the cause of justice and not to defeat it.
Sir, that does not mean that you will come after 10 years and the court will apply this description.
Some, my lord, consideration may be there, my lord, by imposing a minor cost, my lord. Let the WS already filed may be accepted, my lord, that much. Our WS is page 22, my lord.
That what it says the suit is pending?
My lord, suit was stayed, my lord, at this stage of service report, my lord.
So service yet to be completed.
No.
I think the defendant number stand in the suit. Other defendants were there. But the suit is stayed by your lordship. Pardon? By passing.
By earlier order, my lord, 11-12, my lord. Because after justice service, they did not appear. And therefore, my lord, the order 11-12, my lord. Let the suit proceed, my lord.
Okay, we will see.
Kindly, my
See the judgment. Thereafter, we'll take a decision. We'll pass the order.
Obliged. Deeply obliged, my lord.
Number 13.
May it please the lordship. This is a challenge in order to an order dated 2011-2024, my lord, where the ad injunction was made absolute, my lord. So what has happened in this case, my lord? Way back in, my lord, 93, we purchased, my lord, 2 plots of land, the appellant number 1. And in fact, my lord, from the, my lord, original patta, we were residing, my lord, in fact, we applied for mutation, my lord, mutation was pending. Because of ongoing settlement operations, the mutations could not be held. But at this, the provisional certificate was issued to us way back in 1997. We took possession. We constructed a temporary shed and was there. The land was in our possession.
So this appeal is against the order of injunction.
Order of injunction, my lord. That will also be find at page 107.
Yes.
In fact, there was another case, my lord. We drew the case, my lord. Our own condition is that, my lord, in our land, we have been restrained from entering our own land, my lord.
So this appellate court has upheld the.
No, not appellate court, my lord. This is the, my lord, FAO, my lord, first appeal against orders. The suit, my lord, the
earlier, okay.
The injunction, there was an ad interim injunction
order. The earlier order is made absolute.
Exactly. So the earlier order is not on record, but it is in by way of an it has been filed by way of an affidavit. Page 113. This was expertise into order. Lordship may kindly come to page 119, last paragraph.
Yes.
In the light of the contentious nature of the dispute, failure to grant an ad interim temporary injunction at the junction would result in last paragraph, page 119. In the light of the nature of the dispute, failure to grant an ad interim injunction at this juncture would result in irreparable loss and harm to the petitioner. Additionally, if the respondent succeeds in evicting the petitioner from the Schedule A property, it would render the ongoing legal proceedings an injunction access and application futile.
This is only lead to potential financial loss to for the petitioner, but could also result in unnecessary prolongation of the legal process. Given these circumstances, it is imperative that the court intervenes promptly to safeguard the petitioner's right and prevent any further harm or unjust actions. In light of the aforementioned circumstances, the court recognizes the pressing urgency in the dispute at hand, necessitating immediate action. It is imperative that mandatory notice requirements to be waived in this instance to expedite the process of granting the ad interim injunction in favor of the petitioner. The gravity of the situation and the potential irreparable harm and that occur to the petitioner may demand swift intervention to ensure justice and maintain the integrity of the natural legal framework. The last paragraph, therefore, in the light of the above discussion, this court finds that the three golden principles of granting injunction in favor of the petition, case of the petitioner, and the petition is entitled to get relief of an ad interim injunction. In the result, an order of ad interim injunction is granted, restraining the opposite parties to disturb the peaceful position of the petitioner over the scheduled land. The order of ad interim shall remain operative till the appearance of the office party before this court. Now, restraining the opposite parties, here we are the owners of the land, They claim ownership from a vague, In fact, the purchases made, They did not have any entry in the mutation records also, Whereas I purchased the land from the original partaker. When the mutation process was going on, they came inside my plot of land and filed this suit. There is a counterclaim pending, Only thing, had there been a status quo order, I would not have been aggrieved, The only thing, they have, by way of this order, the subsequent order of lordship will find that. And another thing, I'll just take you to page 122, This is the affidavit itself, Lordship will see the patta number, 1500. Dag number, 1500. On the left, it is 421500. This is the case of the plaintiff, Now, Lordship, I'll just take you to the next page, 123. Srimati Kunjabala Patwari, serial number 7. Serial number 7, their claim is, the original patadar had gifted more than 50 bighas of land to this lady. In fact, the original patadar had his wife and children. Leaving aside those, more than 50 bighas of land was gifted to this lady. This lady, sold it to Ohindra Bhushan Das, whose names are not on the revenue records, Ohindra Bhushan Das, sold it to Dipali Devi, from whom is motive serial number 14, This is the plaintiff in the case. The seller's names, they claim that Kunjawala sold it to Ohindra Bhushan Das. Ohindra again sold it to Dipali Devi. Dipali sold it to Urmila Hatimoria. But these two persons' names are not on the revenue records. How it was sold? So, we filed a counterclaim. As well as, we sought ejectment from the land, Now, from my land, I have been restrained. In fact, certain construction works, they were started, but as of now, it is stalled.
So let notice go then.
Notice go, only thing, my whole thing is, in the other case, there were two cases, In the other case, there is a status quo that was made absolute. So that is why, I withdrew it, It was, FAO 11 of 2025. It is by the same parties, The notice may call me in the meantime, status quo may kindly be obtained. Till the retirement of the.
No, like that, we will consider it. Let the other side appear. This IA 941 is for what purpose?
So, in fact, there were two miscases, First, the order 31 and rule 1 and 2 was not mentioned, So, as a matter of abundant question, the other application was filed. there are two stay applications. Well, first application was, the provision was not mentioned. So, my lord, as a matter of abundant question, the second application was filed.
So, first one is 701.
First one is 701, my lord.
You were not pressing it.
No, my lord.
Mr. R.D., learned counsel for the applicant submits that. This interlocutory application may be closed, as he is not going to press the same. Accordingly, taking note of the submission of Mr. D, learned counsel for the applicant, this interlocutory application number 701 of 2025 stands closed. So, let notice go at this is.
Only thing, my lord, because if they start construction, my lord, then, my lord, again the nature of the suit will change. That is my limited prayer, my lord.
No, as per your submission, it is not there now.
No. But because of the filing of the, otherwise, my lord, because of the filing of the case, my lord, they have come to know filing of the case, my lord. That is what, my lord. Only thing, my lord, if your lordship kindly observe that no further construction will be made, that would suffice, my lord. Till the next returnable date, my lord. If any construction is made, my lord, let it be stopped. That is.
No, that is also status quo. And we have to discuss all the ingredients.
No, in that case, I'll be able to point out, my lord, because everything is otherwise on record. In fact, my lord, the plain WS counterclaim, everything is on record. No, lordship, that is what I was trying to impress your lordship in the affidavit. The pattern numbers are also different, my lord. They claim over a different plot of land. I'll just take you to my. Now, lordship will kindly come to page 78. This is the schedule of the counterclaim. Counterclaim starts at 65.
Yes, 78 is the schedule of the counterclaim.
Lordship, I'll take you. Page 78, my lord. A plot of land measuring 1 kotha, 10 less is covered by DAG number 627, KP pattern number 56 of revenue village Swalpoji, so and so, my lord. The next is, my lord, schedule 2, plot of land 3 kothas covered by DAG number 6 so and so. Now, lordship will kindly come to page 35. They mention here the same DAG numbers. Same DAG number 627, pattern number 56. Now, lordship, they rely on a Jamabandi, which I have lordship already referred to in the affidavit, my lord. Lordship has seen. In fact, my lord,
Page number?
Page 35.
55.
35, my lord.
35 we have already shown.
Yes, now lordship will.
Number and pattern number is same.
Same, my lord. Now, lordship, they relied, this is their document, which your lordship will find at page 122 now. The affidavit, in the affidavit, my lord.
Yes.
Now, lordship will see the pattern number is 42. Second column, my lord. And the DAG number is 1500. Now, next page, my lord, serial number 7 I had already shown.
No, whether this annexer 7 was a part of the
Document, my lord. Yes, my lord. They relied on that document. And in fact, my lord, in my written statement, I'll just take you to that, my lord. That was our period case, my lord. Now, lordship may kindly come to page 60. That is the written statement. These are available on records, my lord. Page 60, that is the paragraph 16.
Page 60.
60.
Yes.
Paragraph 16. That with regards to the statements made in paragraph 6 to 8 of the plain, the humble answering defendant denies and disputes the avertments of the plaintiff and actually begs to state that the Jamabandi copy which has been submitted by the plaintiff as Annexure 3 is not the land that belongs to Tag number 627, Pata number 56 of village Saugochi, Moza Belton and so and so, because the Annexure 3 Jamabandi contains only the Tag number 1500N, KP pattern number 42 to old, but name of the seller of the defendant number 1 contains DAG number 627-1505 and KP number so and so, which shown in the Jamabandi and the Sita copy, hence both the schedule lengths are different. That was our period case, Milord. And there is a counterclaim to that effect, Milord. Because this is the Jamabandi has been relied upon by them. They rely on a document, whereas, Milord, in the schedule, they mention a different DAG number and pattern number, Milord. And on the basis of which the injunction was granted.
No. Whether the trial court has not considered this?
No, not even that, Milord. Only thing, Milord, I'll just take you to the final order, Milord. Nothing was considered, Milord. Lordship will find it at page 100, Milord. The final order, Milord. In the injunction, it was nothing was there, Milord. And
yes, paragraph number.
Page 100 is the order, Milord. Page
That's
100.
all right. What is the paragraph number?
I'll just take it, Milord. Paragraph 7, Milord. It starts from there. The court, while addressing the application filed under Order 39, Rule 1 and 2, in conjunction with Section 151 of the Civil Procedure Code, is mandated to examine the 3 fundamental principles governing the grant of injunctions. In the context, the court may scrutinize the conditions of opposing party alongside the documents presented. While delving into the merits of the case, the court has conducted a thorough and careful review of the documents submitted by both the parties. The evidence indicates that as per the petitioner's document, the disputed property along with additional properties was gifted by the original owner, Paramananda Das, through a gift deed number so and so in 1966 to Kunjabala Patwari. Subsequently, Kunjabali Patwari became the owner of the property and subsequently sold 1 bighas, 5 acres of land to Ohindra Bhushan Das via sale deed number so and so, which was duly reflected in the settlement agreement. This is a wrong finding, Milord. Because I've shown the Milord Jamabandi copy, Milord. There is nothing. Lordship may again come to page 122 of the affidavit. Your Lordship will be very clear. The name of Ohindra Bhushan Das is not reflected in the Jamabandi, Milord. How could he sell off, Milord? Lordship may kindly come to page 122 and 123 of the. It, 123 is in the affidavit, Milord. Now, Lordship, Lordship is referring to the affidavit or Milord the order, Milord. Page 123, Lordship will see serial number 7 is the Kunjabala Patwari. Now, Milord, thereafter, Mohanlal Das, Tara Prasanna, Sri Moti Aruna Shivakar, Praveen Chandra Gayan, Moti Viramani, so and so, and 14 is the Milord plaintiff. So, Milord, in between, it is their claim that it was sold to Ohindra Bhushan Das. Then I'll just come to that. Then it was sold to Dipali Devi. They were never the Milord. The names were never entered, Milord. So this is a finding. This is not on the basis of records. The court said duly reflected in the settlement record. Now, Lordship will kindly see additional page 106. Additionally, it is evident from the submitted documents that Ohindra Bhushan Das transferred 1 bigha 3 acres of land to Dipali Devi in 2002. This Dipali Devi's name is also not reflected in the Jamabandi, Milord. So how can it be from the records? Who in turn sold the same to the land to the petitioner, conferring possession. The documents provided by the petitioner establish a clear chain of title and demonstrate a permissive possession over the property. This is absolutely a wrong finding. The opposing parties have maintained that opposite party number 1 acquired the disputed land directly from the daughter of Paramananda Das, acknowledging of that the aforementioned Paramananda Das had initially gifted the property to Kunjabala Patwari. Upon examining the pleadings on record, the court observed that although the opposing parties claimed possession through a registered sale deed, obtained from Parambanan Das daughters, they have not clarified the basis of their position in the absence of evidence of dispossession from the disputed property. Moreover, the opposing parties did not specify the date of dispossession. The learned counsel representing the opposite party during the hearing asserted that opposite party number 1 was dispossessed from the property by the petitioner. However, this assertion lacks substantiation. So, my lord, basically it was on the basis of the ground of possession. But they have, for the purpose of claiming a right, my lord, they have to show the chain. That is not there, my lord. I am in position where they dispossess me. That is true, my lord, because the mutation records were there. Everything was on record, my lord. Nothing was considered. And how could the Miller court come to a conclusion that it is on the basis of the settlement records that this she came into possession of the property, Miller? Whereas, Miller,
No, whether that settlement record was part of the.
yes, because the Jamabandi was produced by them. That is what, Miller. I referred to Miller Annex 3, Miller page, paragraphs here of the written statement, Miller. Just
So the plaintiffs have purchased the land from Ohindra Bhushan Das.
Ohindra, originally, Miller, their claim is the land was gifted to Kunjabala Patubari. Patubari sold a part of the land to Ohindra Bhushan Das.
But his name is not there in the
Jamabandi.
record.
Yes, ma'am. Ohindra sold it to Dipali Devi. From Dipali Devi, Srimati Urmila Hatimoria purchased the land. So this chain is missing.
Okay. We'll pass the order.
Lordship.
Hearing under Article 41, rule to CPC. Item 15.
May it please, Your Lord. Yes, so the appeal against judgment reversal, my lord. I was the defendant in the suit. Suit was dismissed. The appeal is decreed, my lord. My lord, the plaintiff original case is, my lord, that the original owner of the land was one Komirjan Bibi, who owned 6 bigha, 3 katha and 15 lessas of DAG number 479 and Khatian number 154. Now, from that original owner, she left behind, my lord, 2 daughters. One daughter had inherited 4 katha and one daughter inherited 2 bigha, 3 katha, 15 lessas. Now, there's no explanation in the plain manner how both the daughters has inherited different amount of shares, the quantum of shares. Now, the one daughter, Mohiran Nessa Bibi, she sold, my lord.
The substantial question of law is not part of your memo.
My lord, page 7, I guess.
It should be the part of the appeal.
Yes, page 7, my lord. After the appeal ends, my lord, the certificate.
No, it should be incorporated in the memo of appeal.
It is part of the memo. No.
In the memo of appeal itself, it should be incorporated.
My lord, the grounds are there, my lord. The memo of appeal. The substantial question of law, it's otherwise, my lord, we give it separately, my lord.
No, that is the norm. That is not the requirement of law. Come to subsection 3 to section 100.
Sorry, my lord.
Subsection 3 to section 100.
My lord. Shall precisely state the substantial question of law involved in the appeal. No, that's
It is not stated in the memo of appeal.
Yes, my lord, the lordship will find, my lord, the grounds, my lord, that is the same.
Grounds are not a substantial.
Yes, that is the same substantial law. Separately, we have given it in page 7.
Not separately, it should be part of the memo of appeal. There is a decision of Supreme Court also. You file amended memo of appeal.
My lord.
Third, Mr. P. Kosik, Lord and Counsel for the appellant. It appears that as required by subsection 3 to section 100 of the CPC. The substantial question of law is not incorporated in the memo of appeal. And as such, Mr. Kosik submits that he may be granted some time to file amended memo of appeal incorporating the substantial question of law. As is that substantial question of law, here is accordingly allowed, residual is the matter. Next week? Yes.
Item 17 and 18.
May I please, your Lordship?
Yes.
Lordship, on the last occasion, Lordship, I have taken time for filing the substitution petition, Lordship. But that is not required. Appellant number 2 is already on record, Lordship. The name of appellant number 1 may be strike off.
Appellant number 3 is already?
Two, Lordship.
One died, Lord.
One died.
One is the husband of two.
Okay.
Second case to number 17. Petition open.
Appellant number 1 is the husband of
Husband
appellant
of
number 2.
Yes, Lordship.
Okay. So the name of appellant number 1 has to be struck.
Strike off, Lordship.
And appellant number 2 is already there.
Yes, Lord.
She is the wife of appellant number 1.
1.
Okay. Her is F. Begum.
Ahmed.
F. Ahmed, learned counsel for the appellant, and Mr.
D. Kolita, Lordship, on
Kolita,
behalf of
learned
Mr. GP
counsel,
Bhomik. D. Kolita on behalf of GP Bhomik.
learned counsel, appearing on behalf of Mr.
GP Bhomik, senior counsel.
GP Bhomik, learned senior counsel for the respondent. Ms. Ahmed submits that respondent, no, appellant number 1 already suffered demise, and as such, his no, the legal representative are not required to be brought on record.
My lord,
only one wife is there only.
Actually, wife, not one. Main case is suit for specific performance of contract. So in that case, I am, the appellant number 2 is the signatory in the specific performance, not appellant number 1. So cause of action survive with respect to respondent number 2, sorry, appellant number 2. Actually, they have, initially they have filed the suit.
Nice. And in fact, appellant number 2 has signed the agreement for sale.
No. Appellant number 2
is the signatory.
Is short for specific performance of contract.
Acha.
Signatory are they are the signatory. And agreement is with the appellant number 2.
Okay. Submits that cause of action survive in respect of respondent, no, appellant number 2. Appellant number 2, with whom the respondent herein signed the agreement.
Agreement for sale.
Agreement for sale. And as such, the name of appellant number 1 may be struck off from the area of this appeal. Taking note of submission of learned counsel for the appellant. The prayer stands allowed. The name of appellant number 1 be struck off from the area of this appeal at the post appendix of the appellant. Number 2. The learned counsel for the appellant number 2 shall file amend cause title within a period of 1 week from today. List the matter for. So, service completed in respect of the.
Yes, he is represented.
Record received.
Record is there, my lord.
And it is submitted at the bar that service in respect of all the respondents completed, and the LCR has also been received, and the matter is ready for hearing. Accordingly, it is provided that recess shall list the matter for hearing on. We'll fix it that it is 2010 matter.
Hmm.
13th of May.
Second case also same, my lord, because it is a counter claim and counter claim, my lord. The plaint and counter claim.
No, here also you were appellant.
Here also I am appellant. The suit filed by the respondent was decreed and our counterclaim was dismissed.
Okay.
So two appeals.
Okay. Same order. Same order. Same date.
Same order. Analogously, my lord.
Okay.
Item 19.
Recess shall list the matter as no, recess shall list the item number 17 with item number 16 as analogous matter.
Item 19.
Marshal.
May it please your lordship. Lordship, as per office note dated 5/3/25, service has not been completed in respect of respondent number 1, 3, 4, and 5, and 12, not 5.
But in respect of respondent number 1, 3, 4, and 12.
Yes, the rest of the others are complete.
Okay. So you want to take precedence upon these respondents?
Lordship, if it
1, 3, 4, and 12.
Lordship, if it can be fixed for hearing also, no objection.
No, without service of notice.
Then time may be allowed for taking steps.
Pardon me, your good name, please?
BM Chetri. BM Chetri.
Learned counsel for the appellant. Office note dated 5/3/2025 indicates that service upon respondent number 2, respondent number 1, 2, 4.
1, 3, 4. And 12.
Respondent number 2 and 11. Service, no, AD card in respect of service of notice upon respondent number 2 and 11 received. Very good. Login order. 26, 9 to 4. Some other here. 5, 6, 7, 8, 9, 10. To follow office now dated 5/3/2025 indicates that it occurred in respect of service of notice upon respondent number 2 and 11 has been received after service. But neither it occurred nor unserved notice in respect of respondent number 1, 3, 4, and 12 has been received by the section till date. Accordingly, it is provided that the learned counsel for the appellant shall take fresh receipt upon respondent number 1, 3, 4, and 12 by registered post with ATM also by usual process within 2 working days from today. List the matter after data the score. Second. 14th of May. You take a step upon these respondents. 1, 3, 4, and 12.
The number 20.
Hello, please.
Mr. Dubey, do you have the correct address of the petitioner number 1?
You would see an affidavit has been filed by their earlier set of counsel in the record. And they have
No,
withdrawn.
they have withdrawn.
Yes, my lord, and that is on record. That was done in sometime in 2021. And nobody is appearing after that.
Pardon?
And nobody is appearing. Lord, they have received the brief. The client have received the brief from the counsel. And an affidavit has been filed by the counsel, annexing therein that receipt of record. Lastly, also I pointed out.
None request for the petitioner on board. However, Mr. Dubey learned counsel for the respondent number 3 and 4. 3 and 4 present. Rescisal issue fresh notice to the petitioner, number 1 to 3. By registered post within 2 working days from today. List the matter on
26 May. Item 21.
Respondent. And for two.
Oh, up to. ঠিক আছে। My lord, kindly see the last order, my lord. Thank you. May appear fully.
May it please your lordship.
Hmm.
I'm appearing for respondent number 2.
Hmm.
21, 22, and 23.
2.
On the 21, 22, and 23 on the date of respondent number 2.
And Madam Iwapa,
For respondent 1, lordship.
and for remaining respondents.
Lordship, on the last occasion, we have been asked to seek instruction
Hmm.
as to seek instruction as to whether we can represent respondent number 2 to 6.
Hmm.
We have not received any instruction yet, lordship. And
Hmm.
neither they have given us any wakalat number.
Now 2 is appearing, my lord.
2 is appearing.
No, for remaining respondents, 3, 4, 5.
All are from same family, my lord.
Maybe, but they may be in different places.
Not in different places, my lord. All from WS has been filed by jointly also. That is why last occasion, this honorable court was directed to take instruction upon the respondent number 1.
But she has not received any instruction.
All are scattered.
Scattered.
Scattered, I am not able to take the address also, my lord. Kindly provide me address, correct address of the respondent.
You have the address?
This we don't have, lordship. Will
Scattered, they know now address.
we try to manage, lordship.
Okay.
Let
Or
them
Mr.
take
SK
one.
also learned counsel for the appellant and Madam
As they
S. Dev for respondent number 1 and Madam
and A Puja.
learned counsel for the respondent number 2A,
2, 1, 2, 2,
2, 1, 2, 2, and 2, 3. Ms. Dev submits that though white order dated 5/3/2025, the respondent number 1 was directed to collect, to obtain instruction in respect of respondent number 2 to 6. Yet she could not collect the instruction in respect of respondent number 3, 4, 5, and 6. Then Ms. Dev further submits that they are living in different places. Then she will try to collect their respective addresses and furnish the same to Mr. Cruz, learned counsel for the appellant. Within 1 week,
Let them 2 weeks.
within a
Let
period
them
of
2
2 weeks from today. Accordingly, it is provided that rescisal is the matter after vacation.
After viewing.
After due vacation. Yeah, we are fixing it. That
Margin.
Item 22. Item 22.
On the last occasion, there's a deduction for filing on IA. Substitute the names of the legal heirs of the respondent. How is there?
But the petitioner is absent.
Petitioner, probably this, the petitioner, he has also died. I will see the information.
No, on the other day, someone appeared.
No, the previous, at the time of filing the civil revision, this present civil revision petition, the consent petition was there. But then during this period of time, he died. The information that I have received, probably that is the reason why counsel is not appearing.
And it is for the petitioner on call, however, Mr. S.T. Sudre, learned counsel for the respondent. Oh, all the respondents?
For all the respondents.
Oh, all the respondents present. This is the matter after 1 week. In the event of subsequent non-representation of the petitioner, appropriate orders will follow.
23.
We want to do this petition because appellant expired, he has no legal issue, and one wife was there. Long back she came, but she's not, so that he's not interested to pursue the matter. So it may be closed.
Third, Mr. Ahmed, learned counsel for the applicant, and Madam,
Arya, on behalf of Mr. T. Islam.
learned counsel appearing on behalf of Mr.
T. Islam.
T. Islam, learned counsel for the respondent opposite party.
Some of the respondents also expired. We could not
Mr.
take this step.
Ahmed, learned counsel for the applicant submits that. He may be permitted to withdraw this application as applicants are not interested to pursue this appeal.
Appellant already expired, only is full appellant.
Yes, the
With issueless.
appellant has already suffered damage.
Issueless, no issue.
Having heard the submission of learned counsel for both the parties, this court deemed it appropriate to accord permission to Mr. Ahmed to withdraw this application. Accordingly, this IA stands closed on withdrawal. Subsequently, RSA number 2016 also stands.
RSA filing number. RSA filing number, madam.
Okay. RSA stands withdrawn. RSA connected RSA also stands withdrawn.
Hello.
24.
No, dispose of on witness.
May it please your lordship. Lordship, the engaged counsel is out of station, my lord, so let the matter be passed over for the day.
Okay, on the pair being made by Mr.
A day.
Learned counsel for the applicant. No, learned counsel appearing on behalf of
Mr. L. Gogoi.
L.
L. Gogoi.
L. Gogoi.
Yes.
Learned counsel for the applicant. The matter is then adjourned for the day.
It's not okay.
25.
May I please, your lordship. Lordship, as per last order, lordship, we were directed to take steps by way of dusty mood, lordship. But lordship, we have taken steps in the RSA, lordship, instead of IA, lordship. Kindly may allow 2 weeks time, lordship, to take fresh steps.
So you want to take fresh step?
Lordship.
The learned counsel heard Mr.
I mean on behalf of MH Ahmed.
I, Ali, learned counsel appearing on behalf of Mr. M.S. Ahmed, learned counsel for the applicant, and also heard Mr.
And more on behalf of our early lordship.
Learned counsel appearing on behalf of Mr. R. Ali, learned counsel for the respondent number.
1 lordship.
Respondent number 1. The learned counsel appearing, oh, Mr. M.S. Ahmed submits that person to order dated 10/2/2025. He has taken step in RSA number 86 of 2018, but in fact, he ought to have taken a step in the IA number 1110 of 2018. And as such, he may be granted some time to take step in the IA number 1110 of 2018. Where is allowed. Step be taken within 2 working days from today. Precisely is the matter after 4 weeks.
Lordship.
26.
May please, your lordship. Your lordship, my senior counsel has been legs in another court. Your lordship may kindly pass over the matter for the time being.
Who is your senior counsel?
Sir?
Who is the senior counsel?
Mr. R.C. Soikia.
Petitioner is absent today.
Yeah, for
So we'll adjourn the matter for the day. None appears for the petitioner on call. However, Mr.
S. Bora.
S. Bora, learned counsel, entered appearance on behalf of Mr. R.C. Soikia, learned senior counsel, conducting counsel for the respondent number. Do you have a respondent number?
Sir, your lordship, sole respondent.
Sole respondent. Sole respondent. List the matter after 1 week. In the event of subsequent non-representation of the petitioner, appropriate orders will follow.
27.
Your lordship may kindly fix after 1 week. Date.
27.
Oblige, your lordship.
May I please, your lordship? Lordship, as per office note dated 18/7/2024, LCR has been received. And they have also
Matter is ready for hearing.
Ready for hearing, your lordship.
Okay. Heard means your good name.
J.
please?
Sharma.
Learned counsel for the appellant and Mr.
A Pator on behalf of J. Sharma.
Learned counsel appearing on behalf of Mr.
J. Sharma.
J. Sharma, learned counsel for the respondent. It is submitted at the bar that service already completed and LCR has also been received and the matter is ready for hearing. Accordingly, it is provided that recessal is the matter for hearing in usual course.
Obliged.
29.
My lord, in this case, the copy of the CRP IO is not furnished to us. Till date. So the petitioner may be directed to furnish the copy. along
Mr.
with the-
Bora, there was a
I-
direction of this court to furnish a copy of the petition to Mr. Nandi.
Yes, I will have the copy, but really step has properly taken as per record. However, I will have the copy today itself.
Today itself.
Yes.
Heard Mr. L.K. Bora, learned
The
counsel for the
intent
petition.
may be granted. There is in time. Then the last occasion, the intent may be granted on the next date. That is today.
No, there was no such observation.
Yes.
lord.
Yes.
Okay, okay, there is.
My lord, this interim prayer that they have made, it simply does not apply. And it does not arise, and it cannot be granted under so far as the facts of this present case is concerned.
No.
My lord, this, so far as the IS civil that has been served on us, it appears that only one is the applicant, that is Srimati Gitanjali Devi. And she has not sworn any affidavit. Affidavit is sworn by someone else. in
Yes.
this, this
Authorized
thing.
representative,
Where? There is no
attorney.
statement.
Attorney.
No
The
statement.
copy is there. Copy is there.
No,
I'm
copy,
wrong.
we have not
Misleading
received anything.
statement. I
There
am
is nothing. Absolutely, there is nothing. How this affidavit has been sworn, and in place of only one
kindly,
has come
page
up.
number 26, my lord. Page number 26, annex 2 is a affidavit. Attorney.
Mr. Bora, you furnish a copy of the.
Yes, I
petition
today shall I.
Today, you want to file objection here?
Yes, my lord.
Okay.
I'll file the detailed objection.
Then also heard Mr. Nandi, learned counsel for the respondent. Mr. Nandi submits that he has not been furnished with a copy of the petition. Mr. Bora, learned counsel for the petitioner, undertakes to furnish a copy of the petition to Mr. Nandi during the course of the day. Mr. Nandi submits that he will file objection in this petition and press for listing the matter after a week.
After you.
They are allowed, press shall list the matter after a week.
Till next date, maybe that matter may be proceeded.
My lord, where is the?
Let him file objection.
My lord.
Interim prayer will be considered on next day.
My lord. Item 30.
Your lordship may see the order dated 29/5/2024.
No, this IA is for what purpose?
My lord, this order will make the thing clear. My lord, they were required to take steps in the appeal, my lord. Now, the respondent number 1 died. We filed, and as a respondent, we filed an application for implementing the legal heir of the respondent number 1. And the order passed by this honorable court in IA 1496, order dated 29/5/2024. This order you lordship will find in IA 1496 of 2024.
একটা প্রবলেম এখানে বসছে
This IA 1611 of 2024 is for what purpose?
But, here in.
Or releasing the amount?
No, 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 that's a different thing. We are concerned at now, my lord, 1496, IA 1496.
IFO 1496 has already been closed.
Yes, it is closed.
Yes.
But in para 4, your lordship will find
Hmm.
the learned counsel appearing on behalf of the appellant is directed to file a fresh memo of parties on the basis of the instant order by 5/6/2024.
That has not been filed.
That has not been
Yes,
complied.
I am for the appellant lordship. Lordship, I could not file because just I recently have received instruction that my appellant expired, lordship. So that's why I could not file. So may I pray 2 weeks time, lordship, to take further instruction and to file substitution petition if required, lordship. Because appellant died, I have received recent instruction, lordship.
Okay.
That's why I could not file.
Heard Ms. P. Bhattacharya, learned counsel for the appellant, and Mr. S. Dutta. So, since this petition has been closed, we have to pass the order in RSA.
A main
Yes,
arrest.
yes.
Okay.
Only thing, my lord, so far my learned friend is saying the appellant has expired. In that view of the matter, the appellant will have to be substituted.
Exactly, lordship.
But for the purpose of taking steps for the respondent number 1 who expired, that compliance they will have to make.
Otherwise, today, lordship, she is died, lordship. So how can I, lordship, because it,
So your lordship will give some reasonable time to them.
it's 2 weeks, lordship, 2
Okay.
weeks time, I may be allowed.
Also heard Mr. S. Dutta, learned senior counsel assisted by Madam, learned counsel for the respondent. Mr. Dutta, referring to paragraph number 4 in the order dated 29/5/2024 in IA number 1496 submits that there is a direction for filing fresh memo of parties on the basis of the order dated 5/6/2024. But the appellant herein has not furnished the fresh memo of appeal as per direction in the order dated 29/5/2024. Ms. Bhattacharya submits that the appellant number 1 suffered demise, and therefore
Sole appellant, lordship.
sole appellant suffered demise for which he could not file the application and prays for granting her 2 weeks time. There is accordingly allowed recessal is the matter after 2 weeks.
Obliged.
After 2 weeks.
Obliged.
31.
Lordship has said the official dated 27/3/2025.
You are for respondent number 1.
Yes.
Your Lordship, I am facing difficulties to taking a step in respect to respondent number 3. Because your Lordship, you have the claim petition, your Lordship, the address is not clear, your Lordship. Page 8 of my petition, your Lordship, RSA, your Lordship. Without proper address, how can I take a step? Because in the trial court also he is not participate and address also not for. The trial. Yes. Page 8, your Lordship. We have searched, but we have not found any company name in the person, and he is not known to me. Page 8, the petition. Only name is there. Care of Dwarfs Company, there is nothing is there. We have not searched, but we have not found anything. Because that person not appeared, your Lordship. And in the judgment also, your Lordship.
So you collect the address, correct address? And
Why?
take fresh step.
How can we collect? I am searched, but I have not found it, this person. Because it is a stranger. My learned friend can collect because his Representing the respondent one.
Substituted process by paper publication they can do, and that will show that the service is complete.
Because nothing is there, only name, one person. No address is there.
Okay, then as suggested by Mr. Dotto, you take a step. So
There is
service
only
by
alternative.
substituted mode, paper publication. Or inquire from the office of the general manager, respondent number
We have
one.
already inquired, but nothing is found here.
Well, let them take a certificate from the review authority that. Then only courts will, what I understand, that if there is no such address and all that, then he will have to go for paper publication, and that will show that the service is complete. That is the only alternative.
Or Mr. Islam, learned counsel for the applicant, and Mr. S. Dotto, learned senior counsel assisted by Musahari for respondent number one. Mr. Dotto, referring to the office note dated 27/3/2025, submits that the petitioner has not, the applicant has not taken any step upon respondent opposite party number 2 and 3. Accordingly, it is provided that Mr. Islam shall take step upon respondent number 2 and 3.
No, I'll take you. Railway and I'll take. Respondent three only difficult.
2 and 3, within 2 working days from today. Recess is the matter after 4 weeks.
Oblige.
Yeah.
34. 35. Just wait for
35, madam, in this case, we have filed this IA for release the deposited amount, my lord. My lord, may period.
What is the amount?
Amount is, my lord. Amount is, my lord, 8,11,561, my lord. Page 7, para 4, my lord.
So what is the amount deposited before the court?
My lord,
What is the amount they have deposited before the court?
before the court, my lord, 8,11,516, my lord. Page 7, my lord, para 4, my lord, we have stated.
May I beg to interrupt, Lordship? If I am not mistaken, my lord, the IA number shown in the cause list is IA number 382224. So that is a different IA, my lord.
Three
822.
Yes.
This is for condonation of delay of filing.
No, this is for releasing the
Releasing the-
amount.
Apuni bhulke likh diye.
3822 আছে no? বেলে আছে।
322 আছে। আপোনাৰ petition খন বেলেগ।
এখনটো বেলেগ, এখনটো
এইখন আগৰখন। 3727 আপোনাৰ এইটো হেৰি হয় 3727 হ'ব লাগিছিল এই আপোনাৰ 38 যে সেইটো ৰিলিজ হ'ব নহয়
এইটো
দেখুন
এইটো মই পোৱা নাই এইটো মই পোৱা নাই এইটো সেই ডিলে কাৰণে আছে সেকশন 5 ন জানো এইটো
Appeal is already admitted. Where is the question of this condonation of delay?
No, Lordship, they wish to file one cross appeal, Lordship. That is why they have filed one IA for condoning delay in filing the cross appeal. They are the
No,
claimants.
we are not taking up the cross objection now. We are taking this IA number 3822.
In that case, Lordship, I have not furnished that IA copy, my lord.
No, without financing, my lord, we cannot file this IA, my lord.
This
So
one, I
do you have any objection in releasing the amount?
No, my lord.
No. Then we are closing this I.
Lordship, subject to furnishing a bond.
Why?
Because this case relates to death of a person who was working under the government of Assam.
Yes.
And his salary has been received by the family members. So there is no loss of dependency, my lord. So there is a judgment of our High Court also regarding that aspect. So
Okay, madam.
My lord, may Paris page 10, my lord, order of this honorable court, my lord. They have preferred IA, my lord. In that IA, my lord, after hearing both the parties, my lord, this honorable court directed them to deposit 20%, my lord.
that we have deposited, Lord.
12,
No,
my lord.
okay, madam, anyway, you furnish a bond then.
My lord, my lord.
But Ms. Sutia learned counsel for the applicant. And Mr. T. Colita for respondent number for the respondent.
One moment.
Respondent number 1.
1, my lord.
And for respondent number 2. Owner and driver. This interlocutory application is preferred by the applicant for releasing. What was the percentage? 20% or 50%?
20%.
20%.
20%.
For releasing 20% of the awarded amount in favor of the applicant. Person to Ms. Sutia further submits that person to order of this court dated 31/5/2024 in IA number IA civil number 1590/2024 in MSC appeal number 234 of 2024. The respondent number 1 hearing has deposited a sum of rupees 8,11,516, being the 20% of the awarded amount before the registry of this court. And the said amount may be released in favor of the applicants herein. Mr. Polita submits that he has no objection in the event of releasing the aforesaid amount, subject however to furnishing a bond by the applicant's hearing. Taking note of the submission of learned counsel for both the parties, it is provided that registry shall release the aforementioned amount, that is rupees 8,11,516 in favor of the applicants on their furnishing a bond of equal amount. In terms of above, this IA stands closed. Heard Mr. T. Colita, learned counsel for the appellant, and Madam Sutia for respondent number 1, 2, 3, and 4. Office note dated 12/12/2024 indicates that LCR has not been received. Accordingly, it is provided that registry shall issue reminder to the learned tribunal for transmitting the record forthwith. List the matter immediately after receiving the record from the learned tribunal.
There was another side, it was going to time. I will, please come out. If you model, it will want it, that could extend their back. Also to the time. I took 28.
Yes. Consent was not obtained from you.
For taking time, you will also be obtained. They took the time. The model to extend their back.
Okay, interim order will come.
Why not?
28, okay.
3A22. Public.
again, hey.
Lordship, here regarding the stand of the panel, Lordship, there was some query that has been raised by the finance department regarding the monthly salary to the education department. They had raised this query today itself, Lordship. So because the monthly salary part and or the remaining dues that the petitioner is entitled to has to be looked after by the education department.
My lord, education department also in consonance and in compliance with the said order, my lord. And also, my lord, since the query has come at 11:30 in the morning today, my lord, on 2/4/25, finance EC3 department.
Yes.
My lord, they have immediately returned back to the finance department and to the directorate also. My lord, this particular letter in reference to this.
I would give it to the court. Yeah, just show it. You have it, okay.
Thank you.
Now they've forwarded the query to the director of elementary.
Director also. Query was received today at 11. The finance EC3.
No, whether these queries are relevant for the purpose of this writ petition.
Yes, Lordship, because Lordship, whenever this has been done.
Why it could not be released? That is your internal matter. You do it.
Lordship.
But you release this pensionary benefits
This is
Salary.
and monthly salary,
Yes.
monthly salary.
Lordship, here, the role of the finance department, since there is a financial burden on the state exchequer also, Lordship, certain queries are raised so that when they're processing the file, Lordship, these aspects have to be answered. So that is why these questions, because now
No, Mr. Oleha, you have received a file through the concerned department.
Lordship.
It does not mean that without any basis, the department has forwarded the file to you.
Yes, Lordship. Here, the file, they lack certain details which the finance department is querying into, Lordship. And as and when the reply is received, Lordship, it will be processing, Lordship.
No, as and when means you may not get the reply for several years. Does it mean that he will not entitled to salary for such a period?
No, Lordship, no, that is not, Lordship, here, we have been we received the file 1 month back, then while processing, there are certain queries, Lordship, because this will add to the burden, financial burden of the, so certain verification needs to be done. So that verification process is going on, Lordship, and we will try to expedite the process while coordinating with the other, like, education department also, Lordship. So some time may be granted to both the Lordship. Today, they have queried, Lordship. Lordship may list it.
But you bear in mind, we will impose a heavy interest.
Lordship. That I'll.
And that has to be borne by the person who are responsible for the same. We will not spare you.
Lordship here. Lordship, if I can get a extra copy from my learned friend, because so that we can, since we are not a party, so if we can thoroughly verify, Lordship, then because the matter.
No, who is the party here then?
All the respondents are
Education department.
education department only, Lordship.
State of Assam, who is representing the state of Assam? You.
Yes.
Elementary, I'm representing my lord, respondent number 1, respondent number 2. 3, my lord, my senior friend is representing, and my lord, 4, I'm representing 5. And my lord, the rest, my lord, there is no private respondent. So what they have done is, my lord, they have not made the finance department the party, the necessary department. As per the new notification of the, my lord, petition notification. Necessary parties have to be, according to way of, my lord, implement.
And Lordship, here the main crux of the matter is provincialization of the services so that he gets the payment, Lordship. So provincialization aspect is generally dealt with the parent department.
And whenever some extra queries or doubts need to be cleared, that is when we are referred to, like in the instant case. So Lordship may grant us some time in the
No,
meantime.
the service of the petitioner has already been provincialized.
Provincialized.
When?
2016.
2016.
After 2000, yes, Lordship, after 2016, now the finance department has been approached for payment of the regular salary now, Lordship. So these,
That also is important. There
Hmm.
is for, there is for provisionalization, already to 1993.
benefit of
Benefit of provision, at page 28.
Yes. No, he prayed for providing the benefit of provincialization.
Yes, Lord.
And Lordship.
Not prayed for provincialization.
That is since 2016, Lord.
Lordship, after considering all the aspects, this honorable court passed order dated 12th of January 2024, Lordship.
Okay, I will pray for a short date immediately after the vacation. In the meantime, let them clarify and we'll also bring the.
Third, Mr.
I'm R. Islam.
R. Islam, learned counsel for the petitioner. Then Mr. A. Fukan, learned standing counsel for the respondent number 1, 2, 3, and 6, and Mr. S. Kora for respondent number 4. 4. Person to order of this court dated 17/3/2025. I'm 4, 3. Okay. Mr. A. Soliha, learned counsel for the finance, learned standing counsel for the finance department. Apprise this court about the status of file number 228806. Then submits that the finance department has returned the file to the school education department seeking some clarification in respect of non-receipt of salary by the petitioner regularly. And the same has been communicated to the Director, Elementary Education Department. By letter dated 2/4/2025. Mr. Soliha and Mr. Upon learned standing counsel for the finance department and school education department. Press for listing the matter immediately after petition so that they may obtain necessary instruction as well as the status of the file number 228806. There is accordingly allowed recessal is the matter. Immediately after the 23rd.
Lordship.
23rd.
So once the clarifications from the DO comes, Lordship, it will be easier because Lordship, because the provincialization of services in the order also in the speaking order of the education department, they have already written that it will be considered, Lordship. This is a speaking order of 25.
No, my lord, our provincialization is intact, my lord.
Yes.
Till date, it has not been disturbed. That's why, my lord, that interim order was passed, my lord. Subsequently, they have said, without cancelling the earlier provincialization, my lord, subsequently they have said that we are entitled under the new act, 2017. Our provincialization was under 2013 and that has not been interfered with till date. That's why, my lord, this honorable court has passed the order that pay the salary, my lord. That is the reason. Now,
Okay, in the meantime, the learned counsel for the petitioner shall furnish one copy of the writ petition to Mr. Solia during the course of the day.
Mine.
Lordship, there is an interim order that.
Interim order passed earlier shall complete.
Item 34.
May it please your lordship. The service is ready, service complete, your lordship. Maybe fixed for hearing, LC has been received, your lordship.
Wheelchair has been received.
Yes, your lordship.
Both the parties are represented by their engaged counsel. It is submitted at the bar that the service completed and wheelchair has also been received and the matter is ready for hearing. Accordingly, it is provided that recusal is the matter.
There is an
for
IA
hearing.
lordship. The copy has not been furnished to me.
I'll furnish the copy today. Your
I,
Lordship.
there is an IA lordship. Copy
IA
has
is
been
for
furnished.
what purpose?
As for stay of the judgment, your lordship.
Stay has been granted till today, lord. Stay has been granted till today. They have to extend it.
Yes, your lordship. It is still returnable date. Stay of the impugn orders of the trial court as well as the appellate court.
The interim order passed in IA number 3774 of 2024 shall continue. Mr. Colita, learned counsel for the respondent opposite party submits that he has not been furnished with a copy of the said IA. The learned counsel for the appellant undertakes to furnish a copy of the same to Mr. Colita during the course of the day.
Item 36.
In this case, notice was issued, Lordship, and the office note dated 29/3 reveals that service report has not come. Service may be awaited, Lordship. Because there is no stay order, I am praying for a short date, Lordship. Next date in the trial court has been fixed on 21/5. The transfer petition filed by the wife.
Heard, Mr.
B. Haldal.
Learned counsel for the petitioner. Office note dated 29/3/2025 indicates that service report upon the sole respondent is awaited. Accordingly, it is provided that recusal list the matter after 1 week awaiting service report upon respondent.
May I pray for a date after Bihu vacation?
Pardon?
May I pray for a date for fixing a date for after Bihu vacation because trial court date has been fixed on 21/5 before that.
28.
28.
37.
May it please your lordship, dusty service has been completed. Yesterday we have.
You have filed the affidavit.
Yes, your lordship, yesterday we have filed, yesterday.
We have appeared for the respondent. Today we have submitted wakalatnama.
Acha.
So the date the matter come up after you, madam.
After petition.
After the decision.
Lordship,
Pardon,
date
miss?
may be fixed, any
Yes.
date may be fixed.
Good name, please.
S. Sharma on behalf of D. Chaudhary.
Learned counsel for the petitioner and Mr. Sharma for the respondent. Mr. Sharma submits that he has filed wakalatnama today and the matter may be listed after PU vacation. You want to file objection?
Yes. This is
So as to enable him to file objection in this petition, there is accordingly allowed. Recusal is the matter immediately after reopening of the PU vacation.
38.
Like.
Lordship, my petition of Lordship, I am the plaintiff in title suit. Suit was declared in my favor, and there is a money decree of 21 lakhs, with interest. Lordship, stay order has been passed by this honorable court without any deposit. So we file a petition under Order 41 Rule 10.
Lordship, as per instruction of my client, Lordship, I want to withdraw that IA number 199122.
Who's going to interim order लिया था?
Okay. So you can make it over. Reducing stay order.
Otherwise also stay was considered till returnable. It was not disposal.
Maybe. So you don't want to pursue this matter?
Yes.
I.
And main appeal is concerned, LCR has already been received. Parties have also filed Okalatnama. Kindly fix a date for hearing.
After vacation,
So
Lordship,
if
leave
we,
vacation.
Mr. Goswami, if we close this IA, then this interim
Then
order will go.
also my petition will be placed, Lordship, under vacation. If hearing do not take place, Lordship, they may withdraw the IA. My petition will be remain, Lordship.
That will be
I will
infructuous, Lordship.
Whether it will be infructuous, court will consider. Because Lordship, appeal has been prepared without depositing anything. And I'm not getting the benefit of the fruit of the judgment. That is 21 lakhs award. Cases like that, Lordship, I have a 1 bigha of land that was given to the builder for construction of flat.
No, Mr. Goswami. As soon as this IA goes,
Then I can
interim
execute.
order also goes.
I can execute the decree. Then I have the.
Yes, you can. So this petition under Order 41 Rule 10 become infructuous.
May I read Order 41 Rule 10, Lordship?
No, this is for vacation, modification, and alteration of the interim order.
Not only that, Lordship. Read slowly, Lordship.
Ah.
Appellate court may, in its discretion, either before the respondent is called upon to appear or answer afterwards on application of the respondent, demand from the appellant security for the cost of the appeal or original suit or both. This is not question of stay, Lordship. We are not filing application for vacating the interim order. We have filed this petition under Order 41 Rule 10. It will remain, Lordship. At this stage, he can withdraw this petition. Lordship will consider this application after vacation. Immediately after vacation, fix this matter for hearing. If hearing do not take place, we will place this petition.
It may be fixed on hearing there, Lordship. On Tuesday or Thursday.
No, you come to page number 8 of your application. There is only for vacation. There is for vacation, alteration, modification of the order dated 16/11/2020.
Lordship, I have, though I have stated, but petition we have in the cause title we have stated Order 41 Rule 10.
Heard Mr. R. Ali, learned counsel for the applicant, and Mr. Goswami for the respondent opposite party. Mr. Ali submits that he has the instruction to withdraw this interlocutory application. Here is accordingly allowed. This IA stands disposed of on withdrawal. The interim order dated 16/11/2022 accordingly stands vacated. And in
Date may fix for main appeal.
or Mr. Goswami, learned counsel for the applicant. This interlocutory application under section 151 read with Order 41 Rule 10 of the CPC filed by the applicant for vacation, alteration, and modification of the order dated 16/11/2022 passed by this court with IA number 1991 of 2022. Arising out of RFN number 26 of 2022. By which the judgment and decree dated 11/4/2022 passed by the learned civil judge number 1, Governor of Guwahati stands stayed. List this interlocutory application along with the RFA number 26 of 2022 on
24th of April, Thursday.
First week of May.
And
On 6th May. 6th May.
obliged. Highly obliged.
Item 39.
IA number 602, in this IA Lordship notice was issued. There is the condemnation petition of 53 days in filing the MSc appeal.
Whether you have taken a step?
Yes, Lordship, and office note dated 27/3 reveals that
No, there is
service
yes.
service report has not come.
Okay.
In this case
Heard
also,
Mr. Halder, learned counsel for the applicant. Office note dated 27/3/2025 indicates that service report upon respondent number 1 to 6 is awaited. Races the matter after vacation, immediately after reopening of the vacation, awaiting service report upon the respondent number 1 to 6.
Item 40.
My lord, we have filed this application for condoning the delay of 86 days in filing the civil revision petition, my lord.
Okay, hard miss.
P.
Your good
Bhagat,
name?
my lord. P. Bhagat, my lord.
P.
Bhagat.
P. Bhagat, learned counsel for the applicant. Its interlocutory application under section 5 of the Limitation Act 1963 is prepared for condonation of delay of 86 days in filing a connected civil revision petition against the order dated 5/8/2024 passed by the learned civil judge senior division Hailakandi in Meche case number 38 of 2024, arising out of title suit number 4 of 2024. Let notice be issued to the respondent opposite party, returnable in 4 weeks, step be taken by registered post with AD and also by usual process within working days from today. Place the matter after 4 weeks.
Grateful, man.
42.
I for condonation of delay of 21 days. My learned friend has appeared for our respondent claimants.
I don't have any objection, Lordship, if delay Lordship for 21 days. And the matter
But
may be
Mr.
decided for-
Bhatt, learned counsel for the applicant and Mr. Agarwala for the respondent. This interlocutory application under section 5 of the Limitation Act is prepared by the applicant for condonation of delay of 21 days in filing appeal. Connected MSC appeal against the judgment and award dated
22/1/2025.
22nd of January 2025.
It
passed by the learned member. No, where?
MSCT Gwalpara.
No, when the judgment was pronounced?
Judgment was 18/10/2020.
18/10/2024. 18/10/24. Passed by the learned member MSCT Gwalpara in MSC case number 197 of 2020. Why he could not be? Why you could not file the appeal in time?
Let's see, in para number 4, let's see.
Para number 2. What is the
Para
ground?
number 4.
What is the ground?
A procedural delay, let's see, from branch office to regional office. File was
Mr. Bhatt, learned counsel for the applicant submits that due to some official formalities, the appeal could not be prepared in time. And the same has been explained in paragraph number 4 of this interlocutory application. And that the delay is not intentional, rather it is circumstantial, and therefore it is contented to condemn the same. Mr. Agorla, learned counsel for the respondent, opposite party submits that he has no objection in the event of condemnation of delay. Whereas, having heard the submission of learned counsel for both the parties, I have carefully gone to the petition and the documents placed on record and also perused the statement and averment made in paragraph number 4 of the application. And it appears that the certified copy was applied. No, after obtaining the certified copy, the same was sent to the branch office. And it was received by the branch office on 27/11/2024. And thereafter, legal opinion was obtained from the panel of advocates. And after obtaining the same, the branch office had taken a decision for preparing an appeal. Then the matter was reported to zonal office at Kolkata. The zonal office, after going through the same, sent the same to the head office at Mumbai, from which final approval was received. And in the process, some delay had occurred. Then it appears that the delay is not intentional, rather it is circumstantial. And therefore, this court is, and the same has been sufficiently explained. And accordingly, the delay of 31 days in filing the connected MSC appeal stands condemned. In view of order passed in this high, now the registry will proceed to register the MSC appeal and list the same before the court as soon as practicable.
Lordship, if one date may come next week, Lordship, if date may come
No, no, no.
After registration of the. After
Re-
registration.
After registration, they will put up the.
My name may kindly be shown in the post title. Lordship. In the appeal, my name may kindly be shown in the post title.
No, appeal is yet to be registered.
No, well,
We will not pass any order now.
no, for listing of my name, showing of my name, that may kindly be, because in the main appeal, they may not show my name also.
Okay, registrar shall reflect the name of Mr. Agarwala in the cause list.
Is the question.
Obliged.